Bamberger. Today we're going to work a simulated multi-state bar examination type of problem in the area of criminal law. It's problem CrimLaw2. You can find it on my website, www.profbamberger.com. If you haven't already worked problem CrimLaw2, why not take a moment, pause this presentation, go over to www.profbamberger.com, spend about 1 minute and 45 seconds working problem CrimLaw2, and then resume this presentation. Okay, I'm going to assume you've already worked problem CrimLaw2 over at my website. The correct answer is choice B. Should the judge allow these documents into evidence? Answer yes, because offshore lacks standing to contest the search of Edelweiss. This problem is nearly identical to a famous United States Supreme Court case, United States versus Painter. In Painter, the Internal Revenue Service stole and broke open a briefcase belonging to a banker in order to get at records in the briefcase that would incriminate certain clients of the banker. So the goal of the operation was to use the evidence illegally seized from the banker against the clients. The Supreme Court said, number one, a client has no reasonable expectation of privacy in his bank records. That was already established in United States versus Miller. If the client is sharing information with the bank and the bank gives that information to the government, the client has assumed the risk that the bank would give that information to the government. No violation of a reasonable expectation of privacy. Furthermore, if the banker's Fourth Amendment rights are violated, that is a personal violation of the banker's. In other words, the correct remedy of such a violation is that in a trial against the banker, that information should be excluded. In the client's trial, the information comes in. Why? Because the client's reasonable expectation of privacy has not been violated. It's the banker's reasonable expectation of privacy that's been violated, and the remedy of excluding the evidence in the client's trial is inappropriate. So, the correct answer is therefore choice B. The documents do come into evidence because offshore lacks standing to contest the search of Edelweiss. Why does he lack standing? His reasonable expectation of privacy was not violated. Let's look at the wrong answers. First of all, choice A. Choice A says the documents should come into evidence because an overnight guest has an expectation of privacy in a private home, but not in a hotel room. That's incorrect, first of all, on the law. Under Stoner versus California, you have a reasonable expectation of privacy in the contents of your hotel room. But that's not the point. The issue here is that Edelweiss's reasonable expectation of privacy is unimportant to offshore. Offshore, in order to keep evidence out of offshore's trial, would have to demonstrate that offshore's expectation of privacy was violated. It wasn't his hotel room, it wasn't his briefcase. Therefore, the issue of Edelweiss's reasonable expectation of privacy isn't important to this result. Choice C. Choice C says the documents should not be allowed into evidence because the Fourth Amendment rights of Edelweiss were violated, and offshore, who has a transactional relationship with Edelweiss and will suffer injury in fact, can vindicate Edelweiss's Fourth Amendment right through third-party standing. This is an attempt to throw you off by bringing in the constitutional law doctrine of third-party standing and getting you to focus on the issue of whether offshore can vindicate the right of Edelweiss to be free of a search. That's not the issue at all. Okay? The issue is what's the remedy. The issue isn't what's the right. The issue is what's the remedy. Can offshore vindicate the right of Edelweiss? Why would he want to? It doesn't matter anyway. The right of Edelweiss is remedied by keeping evidence out of Edelweiss's trial. Edelweiss isn't on trial. It's offshore who's on trial. So the appropriate remedy to the wrong that Edelweiss has suffered doesn't apply in this case. C is a wrong answer. Finally, choice D. Choice D says the documents should not be allowed into evidence because Edelweiss was acting as offshore's agent and a principal has a reasonable expectation of privacy in the papers of his agent. Edelweiss was offshore's banker. It's a simple application of United States versus Miller to conclude that offshore had no reasonable expectation of privacy in his bank records. The papers in the briefcase belonging to Edelweiss were offshore's bank records. No reasonable expectation of privacy in that briefcase. Therefore, choice D is an incorrect answer.